Good afternoon, everyone, and welcome to today's Professional Advisor webinar. My name is Deb, and I'll be supporting the presenters today. Before I hand over to Andrew and Helen, just some basic housekeeping items. This presentation is being recorded and will notify all registered attendees of its availability in the next week. All attendees are muted today and the cameras will be off for the duration of the presentation. If you have any questions, please pop them into the question function throughout the presentation. Andrew and Helen will answer them throughout at the end of the presentation today. And finally, after the presentation, a survey will be available. Please provide your feedback as this will help us improve our future webinar offering. Now, I'd like to introduce today's presenters, Andrew and Helen, who will present today on death or divorce, which is better. I hope you all enjoy.
Yeah, thank you for joining us for this this webinar, and it's an interesting title, and we just hope the content will match the title. Can we go to the next slide, Helen? So at the outset, as we always do, we of course have a disclaimer that this presentation is intended not to be specific advice, but of a general information nature only. It's always important to get specific advice on your own circumstances or circumstances for clients that you're assisting. So we do make that point, and it's an important one. But at the same time, we do trust that the content we share would be useful as well. Thanks, Helen. So what we intend to cover today are death or divorce, looking at it under four sort of broad categories. The first is looking at testator family maintenance claims versus family law proceedings, and look at how different scenarios will play out in those under those two headings. We'll touch on bankruptcy and the impact that might have on both death or divorce. We'll talk about binding financial agreements and the interrelation they could have with death or divorce. And then lastly, we'll be talking a bit about trust structures and some potential implications to consider in relation to death or divorce. Why is this relevant, you might be asking? And looking at myself on the screen here, I don't know what's wrong with the lighting. I'm looking like I'm opting for death rather than divorce. It's not the best picture, but well, I suppose if my wife saw it, she might opt for divorce. But in any event, why is it relevant? I'm reminded of a case I was involved in many years ago when I was a law clerk, and I was in court, and the lawyer had a client who were acting for the husband at the time, and he was very upset about the advice he was getting about his entitlements to a family law property settlement. And I can't remember the exact figures, but the client got very upset at one point and said, I can't believe she's getting 60% or whatever it was. He said, I may as well kill myself. And without missing a beat, the lawyer said, don't be stupid. If you kill yourself, she gets the lot. And so it is an interesting question. Would she have got the lot had he killed himself? And we will hopefully find out by the end of the presentation. Thanks, Helen. Over to you.
Great, thanks, Andrew. So throughout today's webinar, we're going to look at this fictional typical family, or maybe not typical, but this is our case study for today. We have Mr. A and Mrs. B. They're married. They each have one child from separate relationships. They have assets, property, shares, bank accounts. And then, sadly, Mr. A and Mrs. B have separated recently. Mr. A has also been diagnosed with a terminal illness, so it's a double whammy for them, and he's received bad news from his doctor. And so Andrew and I will discuss various different scenarios and various different kind of situations they might find themselves in, and the advice that we could give Mrs. B in particular, but also sometimes Mrs. A. So we'll discuss that together. Andrew, I think you had some...
Yeah, sorry to interrupt. I just remembered I've completely stuffed up the introduction, and we had some very important polls. So we want to raise a few polls at the start, sort of get a feel for the room, and then we will also conclude with a couple of polls to see if perspectives have changed, having heard the content. So thank you, Helen, for the reminder. So Deb, could we have the first poll up? So not directly related to this case study, but the first poll is, would you rather die or get divorced? That's what we're here to talk about. Death or divorce, which is better? What do you think for yourself? If you had the choice, die or get divorced, please answer that if you're comfortable. The answers are anonymous, I assume. But what would be your preference? Are we able to get the results? Deb, has anyone answered it? I can't see. Oh,
So, Andrew, with your poll, sorry, I have trouble sharing with it. 78% said get divorced and 22% said die.
all right. I'm not sure what to make of that, actually. I hadn't thought that through. I'm sorry to hear both of those, I guess. But the second poll then, so it's not all about us. You know, sometimes we think about, well, death or divorce. I mean, it may be easy for us, but what about the impact on others? Can we have the second poll, Deb? And this is largely what we'll be talking about today, as well as the impact that both these scenarios have on other people. So, would your spouse rather that you die or that you get divorced? What do you think? Do you think your spouse would rather you die or get divorced? People could. I don't want to spend too long on these polls, as exciting as they are, but do we have any preliminary results, Deb?
Andrew, we've got 40% will die and 60% said get divorced.
Yes. I guess one of the things about death is it's all over, isn't it? And then that's what some people say, divorce, you sort of grieve for a lot longer. But we'll be looking at the impact, particularly on the assets, in relation to those two questions. And the third poll, if you thought the first two were bad, what about this one? Would your children rather you die or get divorced? Any preliminary results, Deb?
And the results, 100% get divorced, Andrew.
Wow, okay. Oh, I guess that sort of makes sense, I guess. Oh, well, that's good. They get less money, though. That's, or do they? I don't know. I guess we'll find out. All right, thank you. Back to you, Helen, and our case study.
Thanks, Andrew. Thanks for participating in our polls. So our first scenario, Mr. A, and Mrs. B have separated. Mr. A has been diagnosed with a terminal illness. Mr. A then makes a new will and gives everything to child X. Death or divorce?
Could you bring the slides back up, Helen? I think they've dropped off.
Have we dropped off?
It's probably something I've done. Just keep on your toes.
Is that better?
Thank you.
All right. So death or divorce? Should Mrs. B, if she was your client, make a testator's family maintenance claim, or should she commence family law proceedings? So the principles that we're going to consider in regards to death are, well, first of all, Section 90 of the Admin and Probate Act. Eligible people, actually, only eligible people can make a TFM claim. And eligible people can include a former spouse or domestic partner who at the time of Mr. A's death would have been able to take proceedings under the Family Law Act and has either not taken those proceedings or commenced but not finalised those proceedings and is now prevented from taking or finalising those proceedings because of the death of the deceased. So Mrs. B would fall under that category of eligible people. In terms of family law, though, Andrew, what are the principles at play?
Yes, thank you, Helen. And I suppose just by way of definition too, I suppose everyone is familiar, but a TFM claim is obviously relates to a dispute about the estate. So someone's died, and in this case, Mrs. B would have to wait for Mr. A to die before she could make a claim. But in terms of divorce, that's something you do before people die. And basically, the principles are under the Family Law Act in terms of altering the property. And that's really important to understand that it's the Family Law Act, if someone makes a claim, alters the current existing legal interests of the parties. And it will do that if it's just and equitable to do that. And it will also do that in such a way that the court deems to be just and equitable. So it's important to think about before considering whether a family law claim is appropriate, where the assets would lie without that. So what are the current legal ownership? So things like, for example, if the house is already in Mrs. B's name and she's 100% the legal owner of the property, then she wouldn't necessarily want to alter that. He dies and she's still the 100% owner, whereas if she makes a family law claim, then she runs the risk that 100% ownership would be altered and it can only go one way from there. it also is important to consider that the family law application can only be made prior to the death. So if she waits and he dies, she loses the ability to make a claim. So that's where if someone is terminally ill and it's in a client's interest to make a claim for a family law alteration, then they need to do that before the person dies. If the application has been made before the person dies, it can be continued in certain circumstances, but it can't be commenced. So there is a matter of timing. But as I say, it's really important to start off by thinking, how will the assets be altered? What are the current interests? Things like joint proprietorship and survivorship obviously are relevant. But then the court, in assessing what is just and equitable, would look at a whole host of factors. It'll take into account what the assets are. It'll take into account things like the contributions that have been made by Mrs. B and Mr. A. How did we get to where we are? The length of the relationship, what they both had at the start, whether anyone made any what we call extraordinary contributions, things like an inheritance or a large gift from family members, as well as contributions, not just financial, but contributions to the family. So if they've assisted in looking after children or homemaking responsibilities, that can be counted as well. And then also looking at then what we call the future needs factors. So their respective capacities would be relevant. If Mr. A dies, his future needs are obviously not quite as much as Mrs. B's. His needs in the afterlife are not taken into account, so that's another thing to consider. So the question is, can she make it? Or she could make a claim, of course, if they're married, but it's not always helpful to do so. But it might be.
Great, thanks, Andrew. So if Mr. A dies and Mrs. B has not commenced or hasn't actually finalised her family law proceeding, then beforehand we talked about how she's an eligible person still, but there are different scenarios that could come into play. So depending on the assets of Mrs. B, what is more beneficial to her. So for instance, if in scenario 1, if Mrs. B was asset rich, for instance, so potentially if they had a joint asset and that was the home, and she inherited the home upon survivorship, but she had assets in terms of superannuation or bank account assets, she might be limited in making a testator's family maintenance claim. So that's a claim for further provision, like Andrew mentioned, on a deceased estate. So Section 91 of the Admin and Probate Act mentions that the court has to consider the degree in which Mrs. B might not be able to provide adequately for her own proper maintenance and support. And then also further down in that same section, the court cannot actually award provision greater than the amount necessary for proper maintenance and support. So definitely something to consider, that if she was asset rich on her own terms, then making a Part 4 or making a testator's family maintenance claim might not be in her greatest interest. And then second scenario though, what if Mrs. B was actually asset poor? What if she potentially had a house but didn't have many funds, or multiple different circumstances, scenarios where the assets were all in Mr. A's name? Then she might receive more than she would have in a family law proceeding if she decided to make a testator's family maintenance claim. So the court would generally consider providing Mrs. B with what they say a roof and a nest egg, so somewhere to live and funds for her future as well. But in divorce, it might look different.
Yeah, thanks, Helen. So sort of teasing out a couple of different scenarios from what I said earlier about it. In the first scenario, if for example, if there are significant assets and they're held in Mr. A's name, and it's a long relationship, there's a various intermingling of assets, various contributions. So if Mrs. B had a reasonable family law claim to the assets being altered, then absolutely it'd be worth making a claim on under the Family Law Act before he dies. If, however, the parties both, they've obviously got children from previous relationships. This is a subsequent marriage. They've both probably got pre-existing assets that they brought in. If they've kept those assets separate, effectively quarantined what they had at the start, the only joint asset they've got is the family home. If it's in joint names, held as joint proprietors, and the relationship was short, then she's probably better off not making a claim, because she's unlikely to get more. So the only other thing then to consider, I've just flagged there in the notes, is that the other consideration is the child. Whether the making a claim. I guess what we're talking about here is what's better for her. It's not necessarily taking into account a claim that somebody else might make on the estate. Oh, you're muted, Helen.
Thanks, Andrew. Sorry, I flipped back through my screens. But yes, so the same family, Mr. A, Mrs. B, same scenario and facts. Mr. A and Mrs. B have separated. Mr. A has been diagnosed with a terminal illness. But before we considered, what if Mr. A had made a new will and gifted everything to child X? In this...
Oh, you're on mute again, Helen.
Sorry, technical issues, friends. But we're going to consider in this new scenario, beforehand, we considered what if Mr. A makes a new will and gives everything to child X. We're going to now consider the scenario of what if Mr. A dies before a new will can be made. And there is a big presumption here, or assumption, that there was an old will in place which appoints Mrs. B as an executor, and we're going to assume that Mrs. B also receives quite a large share of the residuary estate or the estate.
You've gone on mute again, Helen.
Great. All right. Well, hopefully you can hear me now. But the effect, the first scenario is Mr. A and Mrs. B have actually become divorced. So divorced is different to a family law proceeding, or Andrew will talk about that in a moment. But the effect of divorce on a will. So this is essentially that Mr. A has actually got a will in place that appoints Mrs. B as the executor potentially. So what actually happens now that Mr. A has died? So Section 14 of the Wills Act then revokes kind of any appointments generally of Mrs. B as the executor, as trustee, as a guardian. Also revokes any disposition to a divorced spouse because they are divorced. And the effect is that as if Mrs. B had predeceased the testator, and so the will be read in that way. But Andrew will speak on that a bit.
Yes, thanks, Helen. So the important distinction is between divorce and actual family law property settlements. This is where a lot of people get confused. That you can have a property settlement the day after you separate, but you can't get divorced straight away. There is some interrelation in terms of timeframes and things like that, but the divorce is separate. So sometimes people sort out their finances with a family law property settlement. It's not the same as being divorced. So what Helen was talking about under Section 14 of the Wills Act, that only applies in the case of a divorce. So if the parties are still legally married, they've sorted out their finances, then Section 14 of the Wills Act doesn't apply, and the will still be valid. And so that's something to consider. Sometimes people sort out their property settlement. The other question is it in their interest to then get divorced, which they have to wait to be separated for at least 12 months before they can apply for divorce. So, yeah.
Thanks, Andrew. Yeah, that's important to note. And especially in our second scenario there, that if Mrs. B begins but does not finalise proceedings, or if Mrs. B does not even begin proceedings in the first place. So she is still defined as the spouse. Section 14 of the Wills Act then does not apply to her. And if the will gives everything to her, those dispositions remain unrevoked. The appointments as well remain unrevoked as well. So Andrew will actually speak later on about how family law proceedings will still be commenced. And so something to consider is the implications of child X So Mr. A's child making a Part 4 claim potentially as well.
Yes, yeah, that's right. And so one of the considerations there is that the family law proceedings, if they have been commenced but not finalised, is that they an application can be made to the court for those proceedings to continue, and often the court will allow that to happen. And so the consideration needs to be given to that. If she makes the proceedings before he dies, she can continue them. But the question then becomes, well, if the will still gives her everything, is there any point in her continuing it? So what Helen's saying is that, well, the will would still give everything, that would remain unrevoked. She would still get it anyway. So the family law proceeding, either finalising that or not having them, might not change anything. But the difference is that in having a family law division, it changes what goes to the estate, and that's an important point to understand as well. That she might receive 100% of Mr. A's assets without family law proceedings, but if his estate is still 100% of his assets, and so it's subject to a claim by potentially his child. So, for example, if there's a lot of money there, then Mrs. B may still receive a good portion of it. Helen can comment more on the specific numbers, but the son is likely to still receive something. So the alternate scenario would be if she continued the family law proceedings or had a family law property settlement, then whatever portion of Mr. A's assets she gets under family law principles become her assets and don't form part of his estate. So, for example, if there was no family law proceedings, say, for example, he had $1 million worth of assets under his will, the $1 million goes to Mrs. B. But if it's challenged, if there's a claim made, then $1 million is part of the estate and she may not receive it all. Whereas if, for argument's sake, say she received 70% of the asset pool under family law principles, partly on the basis that his future needs are somewhat less than hers given the diagnosis, then 700,000 is her property. Only 300,000 forms part of his estate, and she'll get the 300 back, and it may be that the child isn't entitled to anything. So it's still probably worth her while having the family law settlement just to protect at least a portion of the estate from a claim. If no one makes a claim, it wouldn't matter, but that's the risk. Did you want to comment more on that, Helen?
Yes, thanks, Andrew. So that really is what Andrew was mentioning, is kind of a next slide. That is a good segue. Thank you. So what if Mr. A actually never had a will made? And so that means that the intestacy provisions will apply to Mr. A's estate. So if Mr. A and Mrs. B actually did finalise a divorce, then upon intestacy, the estate is naturally distributed to then child X. And there's lots of scenarios potentially, maybe if Mr. A had another partner, that would complicate things further. But generally, if it was just child X, then child X would receive everything. Andrew mentioned as well, what if though there was a family law proceeding in place and a property settlement had been done but no divorce, then potentially that under upon intestacy, Mrs. B could still receive what is called a statutory legacy for a partner. And so there's an amount that a partner receives, and then the residuary estate gets divided that way. So if the estate is actually doesn't exceed the statutory legacy, she would potentially or maybe get the entire estate. That's a very sad scenario potentially, especially if the parties are not get along well, which is assumed if they're separated. And then the second scenario is that what if Mrs. B begins but does not finalise proceedings, or Mrs. B does not begin the proceedings, and this is upon intestacy, no will was made. Upon intestacy, she's still defined as a spouse because there is no divorce in place. And so the statutory legacy, what I just said, applies. And she also is eligible to make a Part 4 as well, and eligible to claim any kind of superannuation death benefits. And so we've seen some sad scenarios where this has happened. Separated spouses have separated for years even, and then the spouse dies, and then the separated spouse comes back and still makes a claim on the estate if there's no will. So definitely needing complex advice or needing some advice is something that you should advise your clients on.
Yeah, thanks, Helen. Can I just comment on that? So it sounds like in a nutshell with that other scenario. Are you able to go back one? I can't remember
Yeah.
what it said. Sorry. So under that first scenario at the top there, where they are divorced, it sounds like whether there's a will or not, would it be right to say, Helen, that if they're divorced, that basically kills Mrs. B's claim on Mr. A's assets? So her only recourse would more or less be a family law claim.
That's
Is that right?
correct. Yes.
Because
Yeah.
by having the divorce, even if there was a will, it revokes any disposition. If there's no will, then she can't make a claim under the whatever the provisions were you said. So if people are divorced, then absolutely they need to get family law property settlement, and there's a 12-month time limit to do that after the divorce as well. So sometimes people can proceed beyond that in certain circumstances, but I guess the advice would be, yeah, if Mrs. B wants anything, she needs to get on with it.
So we'll now consider Mr. A and Mrs. B have separated. There's a terminal illness in place, but Mr. A is also facing bankruptcy. So we'll just make a short point on this, in that in death, actually, so if Mr. A dies, then the bankruptcy rules still would apply to his estate. So the rights of secured and unsecured creditors would still come into play. The priority payments under Section 109 of the Bankruptcy Act, so who gets paid in what kind of order, would still also come into play. And then life insurance policies and superannuation may be exempt, but yeah, that's something to get some advice on as well.
Yeah, thanks, Helen. And from a family law perspective, yeah, bankruptcy can certainly complicate things. The other thing too is so going back where we started, is that it's important to consider what are the existing legal interests of both of them, because that's bankruptcy. For example, if Mr. A doesn't have any assets, then then there's not much there to get. But often a common scenario might be the family home. And just an interesting side note that if the family home is owned jointly, and Mr. A dies before he goes bankrupt, then Mrs. B would receive 100% of that property under survivorship. So Mr. A's share of that property would not form part of the bankrupt estate. However, that would be different if he goes bankrupt before he dies. So better that he dies before he goes bankrupt than Mrs. B keeps the house. If he goes bankrupt and then dies, well, that's a bit sad for her. But from a family law perspective, it does get quite complex. And the short answer is it really depends on the circumstances. Generally speaking, if Mr. A is facing bankruptcy, Mrs. B is probably better to have a family law settlement, because rather than the trustee in bankruptcy having a claim on all of his assets, it may be that there can be an alteration of those interests in Mrs. B's favour before the debts are paid from Mr. A's assets. It is very complicated though, and it really does depend on the circumstances. If it also depends whether they're still together or not. Of course, you can't make a claim if they haven't separated. So sometimes when people are going through bankruptcy, there is separation on the horizon as well. Stressful times, things are not looking good. If that's Mrs. B's scenario, then she probably should get some advice on where does she stand if she tries to work on this relationship, notwithstanding the financial difficulties, or is she going to be better off separating and then protecting potentially some of those assets from Mr. A's creditors. I'll just give a couple of scenarios to illustrate the point. In the first scenario there, they've been separated for a long time, might be many years. They haven't bothered to do a family law settlement. They're not divorced. Mr. A's got a new business and it's not going particularly well, and creditors are starting to sue him to try and make him bankrupt. Well, of course, she should seek a family law settlement, assuming that there's joint assets or that she wants some of his assets. If all the assets are in her name and all he's got is this business that's about to go under, then she might not, she might run a mile. But assuming they haven't divided their assets and there's something to grab, she'd be better to apply for that before everything goes to the trustee in bankruptcy. But another scenario is, and quite a typical one, is that they're not separated, they're still together, but there's a lot of debt. Mr. Ray's doing lots of things that she doesn't know about. She's kept in the dark. He's making bad business deals. All she knows is there's letters of demand turning up in the post, there's people knocking on the door, and bankruptcy is imminent. Well, again, it depends on what she wants to do, but if separation is on the cards, then she's probably going to be better off to do that. In some cases, you can quarantine where debts have been incurred recklessly or negligently, or with complete disregard for her interests. Like, say, for example, Mr. A just doesn't care about Mrs. B, and he's taking massive risks that are not good, incurring all these debts. Well, she may have an argument to say that should come out of his share. So in the ordinary course of events, the liabilities of either of them are joint liabilities from a family law perspective. So, if you've got $1 million between them, he's got $1 million of debt. Well, the ordinary course of a family law settlement would be there's actually nothing to divide. She could get 100% of zero, but it's not going to do much for her. Whereas if you divide the $1 million before you take into account his creditors. So, for example, she might get 60%, 600,000, and then his 400,000 share is divided amongst the $1 million worth of creditors in the bankruptcy. So that's obviously going to be a lot better for her. And there are cases that support that in some circumstances. It does depend, like everything does, but certainly she's going to be far better off separating, preserving her 600,000 than not separating, getting nothing, and then getting 100% of zero. So, it's hard to comment too specifically, but generally speaking, family law is better than bankruptcy, and trustees in bankruptcy generally hate family lawyers and hate family court judges. One of my colleagues who has a lot of expertise in insolvency and bankruptcy has strong views on my area, but the advice is usually family law will get a better outcome in most cases, if they're separated. You can't, of course, separate, do a dodgy deal, she gets the 60%, he gets 40%, goes bankrupt, the creditors get 40 cents in the dollar, maybe they get nothing by the time the trustee's taking their costs, and then all of a sudden a few years later they get back together, and her 600,000 is now joint assets. If it's done deceitfully, then the trustee in bankruptcy can overturn that, of course. So if it's a genuine separation, then yes, family law make a claim usually, or get advice.
Thanks, Andrew. So our next little scenario, we're going to chat about binding financial agreements. So what if Mr. A and Mrs. B had a binding financial agreement in place before their separation? If they had a BFA in place and Mr. A dies, well, death is not defined as separation and wouldn't invoke the BFA. So the BFA does not take effect. And then whatever Mr. A had in place, if he had a will, that would actually take place, or if he had no will, then testacy, whatever that might be. So really important to actually note that a BFA only really distributes assets when you've separated, in the event of separation potentially, but a will actually is what determines the assets in the event of death. So you need really both in place to have a watertight kind of plan. And a BFA also is not effective in preventing a Part 4 potentially. So Mrs. B could still make a Part 4, as we discussed in the first scenario. She would still be classified as an eligible person if they had not finalised a divorce at all, or if she hadn't finished or finalised her family law proceedings. She could still make a claim on the estate.
Helen, can I ask a question? If they've got so in this scenario we're talking about BFAs, so say they had a pre-separation binding financial agreement, so that when they separate, the BFA determines what they both get, it's effectively a family law settlement. Would that prevent her then from, so say they separate, they had a BFA, they separate, they trigger the BFA, Mr. A dies, would Mrs. B be prevented because of the BFA from making a claim?
Potentially, yes. Actually, that's something Mrs. B would need to get some further advice on. Potentially, the court would look at lots of different factors when making a TFM. One of them being really, what kind of she might need, proper maintenance and support, and that might be covered under that BFA, depending on what she was receiving on that BFA. So yeah, lots of factors would come into play in that.
So the way we draft our financial agreements is we generally put clauses in there that say that they're releasing each other from any sort of Part 4 claim. It's probably worth just noting at this juncture, Part 4 testator's family maintenance. But am I right in saying, Helen, they're the same thing?
They are, yes.
A Part 4 claim is a family maintenance claim. Someone challenging the estate. So we, in a BFA, normally would release. And so my understanding, and correct me if I'm wrong, is that the BFA doesn't prevent Mrs. B from making a claim on the estate of Mr. A, but it would be evidence, and the court would take it into consideration. So it doesn't stop her trying, but it would be part of the case, part of the considerations the court would make in assessing her claim. That'd be fair to say? Yeah,
that's correct. Yeah, so the BFA would be part of considering whether or not that BFA particularly has already met her adequate proper maintenance and support. Thanks, Andrew.
Yeah, okay. No, thanks, Helen. So I guess it's an important point that you made, Helen, that the BFA, so people can do BFAs after separation. So I probably should clarify that as well. You can separate, negotiate and formalise your settlement with a binding financial agreement. So that's probably not what we're talking about here. What we're talking about is where people have a binding financial agreement as an asset protection strategy during or before a relationship. So often people, particularly Mrs. A and Mr. B, have already got assets, they've got previous relationships. It's quite common that they get together, they sign a BFA to say if they separate, this is how their assets will be divided. And so that's sort of what we're talking about here, that they've got that BFA in the filing cabinet. And so the question becomes, if they die, if he dies before they've separated, then the BFA has never been triggered, because the BFA only takes effect if they separate. So by signing a separation declaration, it gives effect to the terms of the BFA. So if they haven't separated, he dies, the BFA is completely irrelevant. And that's what you were saying, Helen, that their wills would be what determines the distribution of their estate. However, if they have separated before they die, then the BFA is binding, and it is binding on their estates. So even if they've separated, signed the separation declaration, and then he dies, well, she's only entitled to what the BFA provides for from a family law perspective, and his estate would still retain what the BFA provides for as well, and then his portion would be determined by his estate, his will or any claim, and likewise hers. Helen, did you want to say something now about mutual wills, or have you got come back to that later on?
Oh yes, thanks Andrew for reminding me. Just a side point on that. Potentially, if Mrs. B got some advice and Mr. A and Mrs. B got some advice as well, a possible workaround potentially could be drafting mutual wills. Mutual wills, it's different to actually doing mirror wills. I think oftentimes people think that actually doing a will that reflects the other person's will, just to change kind of the disposition of the assets, is a mutual will. But just because your will reflects that of your spouse's doesn't make it a mutual will. A mutual will is completely different. There's a deed that binds both parties to the will itself, and it means that potentially that upon certain scenarios like death of one spouse, it might be difficult then for the other spouse to change their will. So in this scenario, if Mr. A and Mrs. B had mutual wills, and then Mr. A did die, then potentially instead of, if different scenarios are at play, and Mrs. B then remarried or became partners with someone else, then potentially she would still have to abide by the original will she had made together with Mr. A. So that's just something to think about and something to have your clients get some advice on too.
Yeah, thanks, Helen. So I think probably the main point to emphasise there is that the BFA and a will, they serve different purposes. The BFA is to protect if there's a separation. The will is to take effect if there's a death. And so generally people probably need both, or at least need to consider both.
Thanks, Andrew. And our last kind of scenario we're going to look at today is what if now Mr. A and Mrs. B are still separated, but Grandma A, Mr. A's mum, wants to gift Mr. A assets in a trust. And so we're going to look at death or divorce. I realise the spacebar mutes you in case you didn't know that. So in a trust scenario, if Grandma A wanted to come and get some advice on her estate planning, we were to consider potentially the testamentary trust will. We might provide advice in relation to considering multiple trusts versus potentially a single trust to gift the assets in. So typically each beneficiary would receive their inheritance in a separate trust, which they're the trustee of. But for this kind of scenario with Mr. A and Mrs. B potentially separating, might be worthwhile getting some advice, giving advice to Grandma A in stating that a single trust, noting that in a family law proceeding, which Andrew will touch on, control is incredibly important. So if there was a single trust in the testamentary trust will of gifting those assets to potentially a trustee that wasn't Mr. A, but Mr. A was a discretionary beneficiary of, then that could be a kind of way to protect those assets against a family law proceeding potentially. However, something else complicated and something to consider as well is that if Mr. A was a discretionary beneficiary of this testamentary trust, there is Grandma A wouldn't have the certainty that Mr. A would actually receive any benefit, unfortunately. So just different kind of factors to consider, and what is actually most important to Grandma A is needed to be considered too. And then I don't know if Andrew, you wanted to talk about your divorce family law proceedings now.
Yes, yeah. Just on the testamentary trust, you mean, Helen, or on both?
Yeah.
Yeah.
Yes.
Yeah. So I guess, well, or perhaps do you want to finish, Helen, on the inter vivos? I'll cover both. Maybe might be
sure.
more sense.
Yeah, of course. Yeah. So what if Grandma A actually wanted to gift some assets to Mr. A in a trust during her lifetime, and this is taking, I mean, she's already got financial advice about tax implications, pension kind of implications, etc. But actually a family trust during the lifetime, or if she already is the trustee of a family trust, can be actually a powerful vehicle for passing along wealth through the generations. So you can actually give control of those family trusts now during her lifetime to certain people, and that actually might protect those assets in the trust from other family members who might otherwise benefit from them. If it was a testamentary trust, for instance. So if she wanted to quarantine some assets away from certain family members, then actually thinking about a family trust during her lifetime and nominating certain beneficiaries, or thinking about the succession of the trustees, can be a powerful vehicle for actually passing along those assets in that trust.
Yeah, great. Thanks, Helen. So if I'm understanding correctly, if Grandma doesn't have any assets, if her estate doesn't have any assets, then people can make whatever claim they want, but they're not going to get the assets if they've been gifted in their lifetime. Is that the idea?
Yeah, it might be pointless if there's nothing in the estate, really. Yeah, because the estate only contains what she personally has.
Yeah, great. All right, I'll talk to my parents. So from a divorce perspective, it's really, trusts are a complex tool. Very common, but they can be complex as to how they're dealt with in family law principles. The family court has the ability to not quite do whatever it wants, but effectively it doesn't care what, how things are set up or whose name anything's on, or, the family court has the power to deem things as property even if they wouldn't be considered property under normal trust principles. So that's where, one thing for Grandma to think about is the timing. If she wants Mr. A to get his share of her estate, but wants to protect it from his divorce from Mrs. B, then the testamentary trust would be probably the better option, because until she dies, Mr. B, Mr. A, whoever he is, doesn't have any interest in that. So she could change her will. There's no certainty unless she's literally on her deathbed. The family law principles wouldn't take into account those assets as part of his. So if they've already separated, then definitely she should wait. Or if she's not sure about their relationship and she wants to protect it, then if they separate before she dies, then her assets are safe. It just occurred to me before, it's probably a question to ask when setting up these trusts is, who does Grandma trust? If she is she trying to protect against her children's spouses, or is she trying to protect against the siblings? Like, is she trying to protect from one of her children that she doesn't want to get anything, or is she trying to protect from creditors? That, depending on who she's trying to protect from and what risks she's trying to mitigate, probably determines what trust structure would be the most appropriate. But in this scenario, we're talking about this Mrs. B. Assuming Grandma A hates Mrs. B, as is usually the case, then a testamentary trust may be useful. If she dies, and then they separate, then if he's got an interest in a testamentary trust, it would probably be treated as property in the family law division. It does give some protection. It's certainly better than if she just gave him the assets in her estate, not in a testamentary trust, because if that's the case, then everything's in the asset pool between him and Mrs. B, and he's up for grabs. He would have contribution arguments to say he should get more of it, but he certainly wouldn't get all of it. Whereas if it is in a trust structure, it does give it that extra level of quarantine, I suppose. So, Grandma dies, she's got this testamentary trust, he's operated it. Mrs. B could never say she's made contributions to it. It's been kept completely separate from their other assets. It may still be deemed an item of property, but the assessment of how it should be adjusted would potentially be different to the rest of their assets. So still a good idea, still better than just giving the assets other than through a testamentary trust, but it could still be taken into account. For an inter vivos trust, similarly, it doesn't really matter. If they've separated after they've got it, then it could be deemed to be property. It comes down to control. If he's the trustee, if he's the if he's exercising control over the trust assets as if they're his own, then the court's probably going to treat them as if they are his assets. So you'd have to get some careful advice on that. The timing is important, as I mentioned, I think before, that if Grandma wants to give it to him, the question is, does she give it to him and he's the trustee and he runs it? That's going to be more at risk for his split with Mrs. B. Or does she set up a trust and she's the trustee and she has the ability to make discretionary distributions to her children or grandchildren? That then would probably not be seen as an asset that Mrs. B could get her hands on. So she has the ability to be tax effective with the distribution of income and maintains that control. It might be taken into account in the family law split as a financial resource. So it could impact the adjustment that's made in Mrs. B's favour. She might get a little bit more of their assets, but it would protect Grandma's assets if she's the trustee, or if somebody else was the trustee. But it comes down to control. If Grandma's name was on was the trustee, but Mr. A was the one making all the decisions and he was using it like it was his own money, then the court's probably going to say it's his. So very important to get, if you're going to do something clever, get clever advice. And potentially having other trustees might not be a bad idea, to provide that extra level of protection. Before we go to our questions, Helen, do we want to do our polls? It'll be a shame to run out of time for our polls. So let's, perhaps if people start to think about their questions, hopefully you've got some, so we can answer them, but also Helen can answer them. But we've got our first poll is, having now seen the presentation, would you now rather die or get divorced? Would you rather die or get divorced? Now that you know all that you know, what would you rather? So if people could fill that out, and then Deb will tell us what the results are.
Okay, Andrew, the results are 25% die and 75% said get divorced.
Yeah, right. And how does that compare to earlier?
Earlier on, it was 22% die and 78% get divorced. So
we've driven at least one person to despair. I apologise. Yeah, that's unfortunate. But we have another question that may change the answer. If we had a variable, if we could have the next poll, please, Deb. So, would you rather die and have Helen assist with your estate dispute, or would you rather get divorced and have me assist with your property settlement? So that may have some bearing on the results. What would you rather, die and have Helen assist the estate dispute, assuming there is one, or would you rather get divorced and have me assist you to get as much as you can? What have we got an answer there, Deb?
That's still, no, that's finalised now. So we've got 29% die with and have Helen assist, and 75% with getting divorced and having yourself assist Andrew.
I take that as a personal win. Thank you, Deb. And we were wondering who, death or divorce, which is better. It sounds like divorce, Helen. I'm sorry. You've done death a disservice. Better to get divorced. Better to see me than Helen. Yeah, not because of the company, I'm sure, but because of the legal entitlements. Do you want to comment on that? You have a right to rebut what I've said, Helen.
I think people do prefer to be alive still, Andrew.
Oh, well, that's a good point, I suppose. Yeah, yeah. All right. Very good. Well, do we have any questions? Deb, I know you told me how to find the questions and I've forgotten.
No, if you look in the Q&A function, but I can tell you what it is, Andrew. So, so I've got one question here. If a family law property proceeding has already commenced and Mr. A subsequently goes bankrupt, does the trustee in bankruptcy continue his family law claim? Does the trustee become entitled to all the proceeds of the family law claim?
Right. All right. Yeah. Okay. That sounds complex. Sounds like a question from a lawyer. So if the family, so they're already in the family court. He goes bankrupt. He's not dead though. Is that have I understood that right, Deb? So he's bankrupt but not dead. So the trustee takes over. Yeah, the trustee continues his claim. That's right. And then, yes, that's right. The trustee would be entitled to superannuation. So if he's bankrupt, he loses his right to participate, more or less. He can only make submissions, I think. I'd have to double check this, but he can only make submissions in relation to superannuation. So the trustee effectively stands in his place. He sits quietly and hopes for the best. His portion of the property settlement goes to the trustee and then is divided in the usual way. So if there's sufficient assets to discharge all his debts and the cost of the bankruptcy, then he would get the residual. If there's not, then it's 60 cents in the dollar or whatever they get, and that extinguishes his claim. But there's always a tension between the rights of the creditors and the rights of the parties themselves. So, like for example, the court might say, well, it's really unfair that, say if it was a 50-50 division, the court might say, well, that's unfair that the husband's getting 50% when it's really just going to his creditors. Maybe we should give the wife a bit more, give her 60%. It's better that goes to her than to the creditors. And particularly when you assess the future needs. Like if he's not getting the benefit of the money, then it's not assisting his future needs. So if she's got a lower income or she's got care of the kids or whatever, even if she doesn't, it's assisting her needs more than his. So there is that tension that, well, she would potentially be entitled to more. But the court has to take into account the rights of the creditors. And so that's where the flip side to the argument is, and the trustee in bankruptcy submissions would be along the lines of, we don't care about the wife. It's all joint. The court can give the husband 100% of the assets and the debts could be paid in full. And they should both share in the loss. Marriage is for better, for worse. If the husband won $100 million, ran a successful business, not one. If he earned $100 million, she'd have a handout for a portion of that. Why should she not then also share in his debts? So that's where there is that tension. It's a good question. But I've sort of gone on a bit. But to answer the question specifically, yes, the trustee continues the claim and is entitled to the assets in the first instance, and the bankrupt himself or herself has to just put up with it. But the trustee in bankruptcy can't commence proceedings. So so that if there's no proceedings on foot and he goes bankrupt, it's worth having a closer look at it. Any other questions, Deb?
Yes. Can inheritance to one of the partners be claimed by the other partner in a family law dispute?
Inheritance to one, yes. So yeah, okay, good question. So it depends. Like everything in life, it depends. But yeah, absolutely. If the inheritance has been received before their financial settlement, then yes, it's an asset. So the starting point is the court has to consider altering the existing assets of the parties. So yes, it's part of the asset pool, but it doesn't mean necessarily that the other party gets the same share of that. So it's seen as an extraordinary contribution. So say for argument's sake, if they had $1 million, then all of a sudden there's an inheritance, now we've got $2 million, it's not going to be just a 50-50 that now the wife gets $1 million and he gets $1 million. Effectively, the wife got 100% of what he inherited, or vice versa. But it doesn't necessarily mean it's completely quarantined either. So if there was $1 million inheritance pretty late in the piece, then that's going to give significant credit for that to the person who received it. So say, for argument's sake, the wife received the $1 million inheritance, then she's going to get more than 50-50 of the $2 million pool. You know, she might get, she probably won't get 75%. That would effectively give her all of that, and the rest is 50-50, but she might. That would be her best case. But it'd be closer to the 75 than the 50-50. So yeah, it's part of the asset pool, but it's still going to be more significant to the person who got it. If the inheritance was 20 years ago, say someone got $100,000 20 years ago, now there's $5 million and a lot's happened, then no one's probably going to care. But it depends on the timing. The further back in time, the less weight that's given to that inheritance as a contribution. If someone receives it after separation, then there's a stronger argument to say, well, that should be put in a separate pool of assets. You say, well, that inheritance, yes, it's part of the asset pool, but it should be treated differently because the other person hasn't made any contribution. But it's quite likely it would still be taken into account. If it's received after their property settlement, then good luck to the person that got it. It's all theirs. So that the moral of that story is, if you've got if you're thinking you're going to get an inheritance anytime soon, then you'd want to have a property settlement. If you've got wealthy parents or grandparents or whatever, then yeah, you'd be pushing for a family law settlement as soon as possible, because after your settlement, then that's the end of the story. But if it comes in before then, even after separation, if you haven't had a property settlement, then yes, it's part of the pool. It's up for grabs. Thank you. Any other questions, or did you want to comment on that, Helen?
No, that was fine. Thanks, Andrew. Yeah, that was helpful. No, if there's no other questions, Deb.
I've got a question for you, Helen. Yeah, just thinking, if someone, could you set up a will that was sort of conditional to say, well, I'll give whatever portion to my grandchild, but if they're separated or whatever, then they don't get it? Like, could you build in conditions to a will to say they only get it if they're not separated, otherwise it goes somewhere else? Or
That's a good question, Andrew. Yeah, in terms of the question of can you build in conditions in a will, you generally can. Whether or not those conditions can be enforced or not are another thing. Yes, potentially, yes. It'd be a question of defining whether or not you can appropriately or clearly define what the condition is. So when you say, oh, if this person is separated from this person, then therefore that gift doesn't vest in them potentially. Yeah, it would be up to the drafting of it potentially, and lots of other things. It wouldn't prevent that child from, so if you, for instance, in that scenario of Mr. A and Mrs. B as well, and then if, or Grandma A said if Mr. A is separating from Mrs. B and doesn't inherit, then that might not prevent Mr. A from making a Part 4 because he wouldn't receive anything from his mother's estate potentially. But yeah, lots of things come into play.
All right, I've got another question for you, Helen. If I can't, it was a low percentage that preferred your company over mine. I can't remember exactly, it was 20% or whatever it was. If one of those unfortunate people came to you and said, look, I don't want to give my children anything, can they give it to you? Can they give you their estate? Would that protect it from Mrs. B and Mr.
A? Well, there's something called testamentary freedom, Andrew. So testator, someone who makes a will, can gift assets to whomever they'd like. There's other things, other factors to consider though.
What about undue influence? Wouldn't yeah, so maybe I'll ask that.
Yeah, well, I would have to talk to management about that.
How many of your clients have, maybe I shouldn't know. I'll ask you offline, never mind. Deb, are there any other questions?
No, there's no more questions. Thanks, Andrew.
Excellent. Now, I can't remember, Helen, who was wrapping this up. Was I doing that, or Deb, are you going to close for us?
Yeah, no, I can wrap that up for you. Thank you, Andrew and Helen. I hope everyone's enjoyed today's presentation. This is actually our final webinar for 2024. The program will return next year, so make sure you keep an eye out for any updates and marketing early next year. As I mentioned, we would like your feedback, so please take a moment to complete a short questionnaire following the link and the QR code. Thank you, Helen. And thanks to everyone for today for attending, and enjoy the rest of your afternoon.